Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Before we begin our oral argument cases today, we have a special recognition and a special presentation to Aaron O'Hara O'Connor, Dean of the Florida State University College of Law, who is here with us. Dean O'Connor has led the College of Law since 2016 and has served with distinction in that capacity. We are here today to mark a very important service she performed at our request recently. In 2020, this court named Dean O'Connor to serve as registrant advocate to assist Florida bar examinees during an extraordinary time of turmoil and difficulty associated with the pandemic. And for any of you who were involved in that process at the time, you know how stressful it was and difficult. And Dean O'Connor stepped in and provided outstanding service in her capacity as registrant advocate. So I have a proclamation I wish to present to the Dean in a moment, but I'd like to read a portion of what is set forth in the proclamation. Whereas Dean Aaron O'Hara O'Connor was named by the Florida Supreme Court as the registrant advocate to assist Florida bar examinees with issues related to testing software, testing accommodations, or the temporary supervised practice program after they faced unprecedented challenges taking the bar exam during the pandemic and the cancellation or postponement of scheduled bar examination dates in 2020. And whereas Dean Aaron O'Hara O'Connor gave extraordinary volunteer service as the sole registrant advocate in Florida, communicating with and making herself available to all 3,137 applicants who took the examination, listening to their concerns, assisting them in navigating the pre-examination process, and crucially, providing a consistent voice of reassurance and calm to the examinees as they face the uncertainty of a first-ever online administration of the bar exam during a global pandemic. Now, therefore, be it resolved that the Supreme Court of Florida hereby expresses heartfelt thanks to Dean Aaron O'Hara O'Connor for her dedicated service and immense contributions to the Florida Board of Bar Examiners and, more importantly, to the preparation and support of examinees for the bar examination. Dean O'Connor, on behalf of this court, I want to thank you for your extraordinary service. We applaud you. And so now it is my pleasure to present you with the proclamation we have framed here. And I think we're going to get a picture too, so. Congratulations. We're now prepared to move forward with the consideration of our cases. The first case we will consider today is in re amendments to the rules regulating the Florida bar.
May it please the court, Kevin Cox on behalf of the Florida Bar. We've agreed that the bar will take 11 minutes of the time. The sections are also, there's some sections here who are commenting, and I just reserve 1 minute for rebuttal. Good morning, everybody. This petition to modify a series of rules within Chapter 6 of the rules regulating the Florida Bar affects legal specialization education, specifically the certification of specialization. There are a number of changes, but the principles are basically the same. To take from the individual certification areas concepts that are general and common across all certification areas, and to move them to the front part of Chapter 6, which addresses the general standards for all of the rules. This will increase consistency, it will avoid repetition, and due to the special nature of Chapter 6, it will more clearly put this court in the authority position for criteria that affect general standards, discretion, and other aspects and mechanics of the rules that really go across all areas. So with respect to that last point, individual certification areas, the objective criteria, for instance, for appellate certification or family and marital law certification, those changes can be made pursuant to this court's rules by the Board of Governors as final action once it's submitted to the court, but not through a formal rule petition like this one is. The overarching initial part of Chapter 6, the part that doesn't address the individual certification areas, can only be modified through formal action as final action through this court. And so what's happening here is that the bar is proposing to move those provisions that really are general in nature and over time have become somewhat inconsistent with respect to things like discretion or things like waiver or other aspects that really don't have a specific connection to the individual area. Taking those from the individual certification provisions and moving them to the general provisions that become final action pursuant to this court's action. So in the specific areas, the rules, there are three at issue, but the really key ones here are 6-3.5, which is certification, and 6-3.6, which is recertification. And in this instance, the Board of Governors has gone ahead and made some contingent changes to the individual certification areas that are dependent upon the court's resolution of the changes to the overarching sections at the front end of Chapter 6. There are also, and it's a routine matter for the Board of Governors, the bar to make changes to the certification in those individual areas. The intent and the purpose of their ability to do that is so it doesn't take a lengthy formal proceeding to make modifications to address whatever changes.
Well, a lot of the controversy that's been expressed by the commenters is really directed at those changes that are not even before us. Isn't that correct?
That is correct. There are certain changes that were made in December in connection with this overall change that the Board of Governors made directly. For instance, there's one with the appellate certification, appellate practice certification that eliminates discretion for certification based on good cause as defined in that individual area, because that's a relatively unique provision. Now, there are, and for the family and marital law section has a similar one where there could be a waiver of requirements for recertification based on substantial contribution to the field. The Board of Governors determined that those can already be taken out. They're not consistent with across areas, and as part of this proposal to the court, the good cause can be defined within 6-3.5, and the instances in which good cause can be exercised by the committees who look at these certifications and recommend certification.
But is that on certification or recertification?
So in 6-3.5, there's a definition of good cause, but that applies to the entire chapter. So, and it says this, for purpose of this chapter, good cause is defined as, and that gives the court the opportunity to explicitly put forth the criteria that those committees will use in exercising discretion some of which is applied in recertification, some of which is actually still applied in certain instances within the individual areas. But good cause as a single definition, this court provides that definition. And so these certification committees, which do an exemplary job and have always done an exemplary job of using their prudence and their experience to make good determinations, they have a standard and a scope and an authorization for discretion that is authorized directly by this court. And they can rely on that, and we want them to continue to use discretion, but this gives a better definition of discretion, makes it more consistent, and avoids some of the variances that have occurred in the individual certification areas. There is the commenters suggest that, and I'm glad the court has the benefit of the input of the sections that have commented. I think it's very helpful. They have suggested that because of these changes, there are going to be instances where very obviously well-qualified, highly competent practitioners are not able to obtain certification or recertification as a result of the reduction in discretion. That is not the anticipated effect or certainly the intent of these modifications. Rather, as I mentioned before, there still will be the application of discretion. It will be defined in the general standards as defined by this court. In certain instances, discretion for certification on the front end within that appellate rule I mentioned, within the family and marital law rule I mentioned, that will no longer be present. However, the bar's position is that if there are instances where it is difficult to obtain oral argument or is difficult to obtain opportunities to try a case in a first year, whatever the quantitative requirements are, that those candidates should, the certification process should still render those candidates, the way to solve that problem is not by relying on discretion. That's not the mechanism, but rather to change the objective criteria, which the Board of Governors, pursuant to this court's authority, can do quickly and nimbly. And in fact, even in this year, the number of oral arguments has been slightly modified. That was pursuant to action in July. There was an issue regarding protracted litigation and whether protracted litigation would qualify for criminal certification. That change there's a change that has been made by the Board of Governors, and so that the right tool to adjust for any concerns about changes in the legal industry or changes due to the pandemic.
And those changes are directly responsive to concerns that have been raised in the comments.
I think the bar listens to comments, and I don't know if it was these specific comments, but I know that there's an ongoing dialogue about the way to make these rules better, to improve and increase these rules. So increase the efficiency of these rules. As the Supreme Court has recognized, the certification system is a good system. It's very important to serve the public. It recognizes these good lawyers. We think the system will continue. This will only it will continue to serve that important purpose, and the way it does, this will only serve to improve the way that the certification process goes. Again, we don't believe there's a problem or there's ever been a misabuse of discretion. Rather, this is just, in looking at the way these have developed over time, this is a way to make more consistent and to put in this court's direct hands the delegation of authority to these committees that are doing this important work. If there are no other questions, I'll reserve the rest of my time.
Very good.
Thank you.
May it please the court, my name is Chris Donovan. I'm the immediate past chair of the Florida Bar's Appellate Practice Section, on whose behalf I am appearing. I'm also appearing today on behalf of the Trial Law Section and the Public Interest Law Section, at least for purposes of oral argument. I would, in response to Justice Kennedy's question, the changes that were made with respect to the oral argument requirements were done in direct response to the loss of discretion. And I think it's worth emphasizing that the bar's extensive rule amendments are essentially a solution in search of a problem, because even today, the bar has not explained why we are making all of these significant changes, particularly removing the certification committee's discretion. They admit that there's no problems with how it's been operating. They admit that there's been no abuse of discretion. They admit that there's no flaw or insufficiency in the rule. and that in terms of the bar's words, that certification committees do exemplary work. And Justice Ansted's comments, it's the crown jewel of our Florida judicial system. So why then do we remove the privilege or the ability to allow these certification committees to exercise their discretion when there's good cause and sufficient for applicants? And the bar's identified essentially two reasons stated in the application, but they simply don't add up. The first is to standardize and to avoid repetition, but rarely does one size fit all. And that's particularly true for certifications across 27 different practice areas. And it really doesn't explain, though, why to remove the discretion from some committees, but leave some discretion for others committees. And it certainly doesn't explain why we're doing it now. Why after years of certification, which has been around since at least the early 1980s, why change the discretion now? And indeed, the consistency isn't even achieved because, as I said a minute ago, some committees retain some of their discretion, others lost their discretion, such as the Appellate Certification Committee. The second major reason why they've tried to make these changes is to ensure major changes and any discretion is authorized by this court. But the Florida Supreme Court the Florida Constitution already recognizes this court's authority to supervise and to rulemake, and that's provided for in Article 5, Section 2 and 15. So presumably also this court recognized anytime there's a new certification, this court approved the certification committees and the existing rules. And I know that's for sure true for the appellate rules, which was created in 1993 at 621 Southern 2nd, 1032, that specifically included the exact language of allowing discretion for good cause reasons with respects to if somebody didn't make 5 oral arguments, instead they only had 4 oral arguments. And that's the very same language that the bar has removed and that this court had previously approved. So this court has already approved that which they're trying to remove. And it's worth emphasizing that the removal of the discretion is in effect today. As Justice Kennedy pointed out, it isn't contingent on what this court does and approves in the petition. It's already in effect. So there are currently applicants.
But how is that before us? I mean, I understand you've argued about it and you can talk about it, but in terms of, how do we, it's not really been properly teed up for us to reach out and grab that, has it?
I think this court does have the authority.
Well, I mean, we've got the authority to obviously over any of that, but it's typically, unless we do something sua sponte, and people want us to do something, there's a process they go through to tee up the issues for us, and I think you got to get 50 lawyers to get a petition, and if you can't convince them to do what you want them to do, there are ways you can come to us with a petition.
Well, with respect, Your Honor, I believe that, as I understand that the process that created these current rules that are before you are all part of the same changes. So if the court were to deny the petition and basically send it back to the bar to make changes, this court could, within its authority, I think, also tell the bar to return the discretion back to the way it had originally approved it, such as in 1993. And I think that it's worth emphasizing that, as I've already addressed the 2 reasons that they've identified, I think there's we're left with speculation for why they made all of these changes. At first, the sections believe that it was because of the recent 2018 trade union case out of the U.S. Supreme Court involving Janus versus American Federation of State, County, and Municipal. And as this court's probably very much well aware, that involved mandatory union dues to be paid by non-union members, which the Supreme Court declared was First Amendment. But we've quickly realized that doesn't apply because certification is voluntary. No dues are taken from non-certified members being paid to pay for this program, at least as I understand it, and there's no speech involved. In fact, the certification committees can't take ideological or political positions. They couldn't even take a position in this rule comment. That's why they reached out to the sections who could take positions. Recently, we've become aware that what is possibly the bar's concern is a 2015 antitrust case called North Carolina State Board of Dental Examiners versus FTC, which appears at 135 Supreme Court 1101. But that case is extremely distinguishable because it involved a dentist licensing board that had active market participants, in other words, licensed dentists, sending cease and desist orders to non-dentists who were performing teeth whitening, claiming that that was a part of the conduct of dentistry. But there's in that case, there was no clear state rule stating that teeth whitening was a practice of dentistry, and the FTC so sued, claiming that this was an antitrust violation. And the state board countered with this as a state immunity defense. And so the U.S. Supreme Court refused to recognize a state immunity defense in that case because there wasn't sufficient oversight by a state sovereign. And I believe that's why the Florida Board of Examiners, or excuse me, the Florida Bar Board of Governors are concerned about that case because they keep saying that they want this court to have supervisory authority over any rules that are changed or any discretion that's administered. But there's two problems with that. As I already mentioned, this court already has supervisory authority. It initially passed these rules with that discretion. And it even has supervisory authority over individual denials by applicants because Florida Bar Rule 6-3.10 allows for an amendment, or excuse me, allows for an appeal for an applicant who has been denied certification. It goes through the Florida Bar Board of Governors appellate process, but eventually will be reviewable by this court through petition for cert. So the state immunity defenses already exist under for the Florida Bar.
We don't have a petition for cert?
Yes.
We don't have cert jurisdiction.
Under Rule 6.310, it provides that this court has jurisdiction to review a denial, and I believe it refers to cert jurisdiction, but it has to exhaust the Florida Bar Board of Governors administrative remedies first. So, I mean, this court does have supervisory authority in an extreme situation where somebody has been denied the exercise of that discretion by the committee. Second, it doesn't even involve certifications do not involve antitrust matters. Simply because you are board certified doesn't mean that board certified attorneys have a monopoly over the practice of a specific area. In fact, there's approximately 200 board certified appellate attorneys, but yet there's thousands of appeals being filed every year. In fact, so much so that this court has recently certified the need for a 6th judicial circuit. So there's clearly not a monopoly by those in a particular area over the practice of that area. Nor is there any evidence of price fixing or guaranteed higher compensation simply because you are board certified. Yes, they may be able to charge more, but the clients typically go somewhere else if they don't want to pay for that. There's simply no evidence that antitrust is being involved here, and in fact, removing the discretion of the certification committees it creates the antitrust problem because it makes it harder for people to become certified and to remain board certified, and therefore this court. The bar has essentially got a solution that they are trying to bring within the state immunity exception when there really is no antitrust problem. But if this court is really concerned about the belt and suspenders, or the bar is, then other way to do that would be to remove the Florida Bar's ability to make any changes to the certification on its own by amending 1-12.1a, which would eliminate the bar's authority to amend the certification areas without this court's approval.
Can I ask you, what was the role of the Board of Legal Specialization and Education in this process? I see that they voted in favor of it 15-1.
Yes, Your Honor. It's my understanding that, and it's my understanding that the Board of Governors drafted the original changes, and then it went, I could be wrong here, but it went through the BLSC and then was proposed up to them. So there was maybe a committee that started these changes, this process.
Did the sections you represent have input at those stages?
Not that I'm aware of. We discovered this, Your Honor, back in December when I received a phone call from the appellate certification chair saying, "Did you know about this?" And as I understand, at the time, I was questioning whether or not it had even been advertised. I know that it has been advertised because they've put that in their petition. There was I think we all kind of missed some things because of COVID or whatnot, and it was advertised apparently in the Florida Bar Journal, but or excuse me, the Florida Bar News. And so once we discovered that's when we tried to prepare, because at that point it had already been approved by the Board of Governors, as I understand it, and was in prep for being filed in this court for a petition. So that's when we started moving towards filing a comment at that point. And see that my time is up, so I will yield the rest of my time to the family law section.
May it please the court. My name is Heather Apicella, and I'm the current chair of the Family Law Section of the Florida Bar. I'm here on behalf of the Family Law Section. To answer your question, Justice Kennedy, I do believe that you have the right to deny the petition and reinstate certain provisions that have been stricken by the bar that are detrimental to family law. The Family Law Section was created in 1973, and we have 3,757 members. 271 of those members are board certified in marital and family law. That's 7% of our membership. The process of becoming board certified is extremely rigorous. The initial application process itself weeds out many, many applicants. And then if you're able and eligible to sit for the examination, historically 10 to 15% of those lawyers who sit for the examination actually become board certified and pass it. The Florida Bar, once a lawyer obtains his or her board certification, stripping the ability from that lawyer to have the ability to argue that there's good cause because they don't fit into a bright line rule is devastating to the marital and family law board certification as a whole. The family law section's concern falls squarely with a serious and significant revision to the rule solely impacting the recertification applicants. Under Rule 6-6.5B4, which has been now stricken in its entirety and placed up above in 6-6.5, now only vests discretion in the Board Certification Review Committee for lawyers who have been continuously practicing law for more than 14 years that are continuously board certified. You're talking about a group of lawyers that in marital and family law likely are practicing for 25 plus years or more. Lawyers in marital and family law do not sit for the board certification exam historically until they're in practice for 10 plus years. So in order to be board certified continuously for 14 or more years, you're talking about a lawyer who is 25 plus years of practice. Having the trial requirement in family law is very, very difficult. Family law rules as applied to the recertification specifically vest the certification committee with the ability upon good cause shown to waive the trial requirement for those recertification applicants or the substantial involvement. We operate under the bounds of advocacy. This court has repeatedly cited the bounds of advocacy. The rules of professional conduct specifically, the bounds of advocacy specifically state that the rules of professional conduct are overarching on all sections. And the reason that the family law section and the family law lawyers cannot be couched with all other members of every other practice area is because we're so unique. We operate with the standard of achieving resolution. The bounds of advocacy require that all family law lawyers attempt to consider and achieve a means of appropriate resolution without court intervention if possible. This is consistent with the mission of the family law section of the Florida Bar. In 2017, this court adopted the rules that applied to the Act, the Collaborative Law Process Act, which became in effect on July 1st of 2017. The Collaborative Law Process Act is a non-adversarial process, completely avoiding the need for trials and for formal discovery. Justice Pariente, in the case of Perlow versus Berg-Perlow, 875 Southern 2nd, 383, specifically stated that it was the vision of this court that for our principles of our unified family court, that we work to settle disputes as amicably as possible. She also encouraged alternatives to the adversarial process. She empowered litigants to reach their very own solutions, to assist in crafting solutions to promote long-term stability. The bar's revision to this rule, which by their very own words have been to seek uniformity throughout all sections, will now place the family law lawyers into a black and white rule in a very unique category, requiring trials and requiring those very lawyers who may have good cause to no longer have the ability to waive the substantial involvement requirement or for the trial requirement. This is contrary to the public policy as articulated by this very court. It's the opposite of the
Counselor,
ethics.
you're in overtime now by about half a minute. If you could go ahead and sum up in about 30 seconds.
Sure. For a lawyer to know that his or her board certification, one of the most grueling processes that he or she has ever had to go through, one of the most biggest honors of that lawyer's career, to have that same achievement stripped from him or her because they are abiding by what the legislature has mandated, this court has mandated, is absolutely devastating. It is going to be the death knell of the board certification in marital and family law should you strip the committee with discretion. The family law section is requesting that this court deny the petition and instead reinstate the provision that was stripped by the bar in 6-6.5 before. Thank you.
Thank you.
Hey, please the court. Mike Lefferman on behalf of the criminal law section. Let me try to summarize it this way. Prior to December of last year, each of these certification committees had their own discretion to grant a waiver if someone didn't meet a minimum requirement. In my section, for instance, with criminal law, if someone wanted to be recertified and they didn't have the 5-trial minimum, but they were involved in protracted litigation in a federal case that would last several months, we've recently read about that in the Tallahassee papers over the last couple months, they could say, look, I'm a specialist in this area, I've been certified before, I want to maintain my certification, count this trial as 2. I have 4, not 5, but I have this 1 trial that's protracted litigation. That existed prior to December. Where we are now is there's been an effort by the bar to strip most of that discretion from all of the individual certification rules and then put discretion only in 6-3, which would have then applied to all the certification committees. But the only discretion that exists under this proposal is for health. So let me repeat that. Up until now, there's been, hundreds of lawyers over the last 2-3 decades that for whatever reason couldn't meet some minimum requirement, and the committee had the ability to grant a waiver, and now that is gone.
There's no discretion on anything else, including the period in which the experience occurred?
No, the only discretion under this proposal is health or the 14-year waiver, which had always applied for people that have been certified for a period of 14 years or longer. It's the people in between that we are most worried about. So what we are suggesting is this, because you've brought up this idea. This happened in December where the section's involved. I'm not sure that there was good communication for all of this. But so I would ask this. I would ask that you send this back. Send this back to the bar. Ask that they get the committees involved, the sections involved, and come up with, if the purpose of this is to move all of the discretion into 6-3, which would then always be approved by this court, great. But allow us to have more input as to whether or not there should be additional factors beyond health that would allow some type of good cause exception. Because right now, again, I served as the chair of the Criminal Law Certification Committee recently. I was on the committee for 6 years. In that room, we deal with lawyers that come to us, and it's rare. It's not most lawyers meet the minimum requirements, but some of them come to us and say, look, I have this extenuating circumstance. I was asked to write a treatise in a particular area. That's good. We want that lawyer to be certified, and we're also willing to look into whether or not we should count them writing a treatise in DUI law as one of the trials. This will take that away, and we're simply asking, send this back. Let's all get together at the table, all the sections that have now commented. Let us get together with the bar, and I think we can come up with a solution. But if you approve this now, and the only exception is going to be health or the 14-year waiver, the Board of Governors, next time around, if all these committees within themselves try to come up with a new rule that says, let's bring the discretion back, I think the bar is going to take the position that, nope, we've now put all of the discretion into 6-3. The Supreme Court's approved that, and these are the only reasons we're going to allow for discretion. We like their good cause definition. That should apply to all the committees, but please send this back for further consideration. Otherwise, I think we're going to lose out on a lot of very talented lawyers that should be certified. Thank you.
Thank you.
The only comment I would make in rebuttal is, again, that what we've heard about what the impact would be if this discretion is removed, the bar's position is that those things can be addressed through changing the criteria, the objective criteria, the quantitative criteria that the sections have expressed are sometimes missed. And there are very highly qualified attorneys who can't make the certification requirement because they can't meet a certain quantitative criteria. those criteria can be changed, and they can be applied uniformly across the attorneys who are applying without having to rely on the discretion of the committees to make constant waivers or relaxing requirements. To the extent that there is a health waiver that is now provides good cause for health, there's also within the recertification process, there is a sentiment that recertification is something where attorneys are extremely well qualified, they've demonstrated that, and so that's why
Let me ask you this. How do you respond to the family law section? There are some areas of the law, some divisions, criminal, civil, family, where it is more difficult to actually get a case, get a trial, 5 trials. You can be working 24 hours a day. It just doesn't happen because your whole goal is to resolve the case as quickly as you can for your client, and that's what we want. But how do you respond to this whole idea of one shoe fits all that I think you want us to do when you had divisions with different needs, different approaches, things like that? It's hard sometimes to get 5 trials if all you're doing is mediating and resolving cases.
Yes, Your Honor, it's a very good question. And the goal is not a one-size-fits-all with respect to the quantitative requirements, so that an appellate lawyer, how many times they go into a courtroom is the same as a criminal, is the same as a family law. If a highly qualified family law attorney should not need to show as many trials, that criteria can be adjusted, the actual specific number, rather than asking.
Well, who decides that?
So there are standing policies for how these certification committees work. So the individual certification committee, which also is the committee that reviews these applications, continually also looks at the metrics that are used. They would make a recommendation to the Board of Legal Specialization and Education. They would review and say, yes, this looks like something where times have changed and now we need to reduce this number. Let's present this to eventually go to the Board of Governors, and the Board of Governors would say, yes, only X number of trials should be required for this individual area, and that change can be made without formal action by this court. It's an individual specialization area. The petition that the bar is asking for here is simply to the overarching standards that would apply to all. With respect to the family law section, their particular waiver was for anyone who made a substantial contribution to the field, and rather than allowing the committees to move on that standard, the bar believes it's better to have a more defined objective criteria and a more defined good cause standard for when it would apply. And it does, as they point out, it's more applicable to recertification than certification, because the idea is that certification the qualifications can be readily set forth with specific quantitative matters that don't need to be relaxed continually with discretion.
All right, thank you.
All right, thank you. We thank you all for your comments in this case today.